Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for political law enforcement training, bringing you another roadside chat. Hey, Michael, are you an attorney? Michael from Nevada, are you an attorney? That's awesome that you're here. Judge, tell me what you're or cop, right? So I'm glad you guys are here. For those who are watching this on demand, just kind of bailiff, awesome. Please know that this is recorded live, and so as I was making some conversation with my fellow Nevadan, Michael over here, you're going to see that I'm looking at the chat and so forth. Sometimes people have questions and maybe a follow-up question, or they might just have something to kind of add some commentary to add. I might make a comment on that too. We're going to be here for about an hour. And then after that, we're going to do a search and seizure show where I answer your questions live. I do have some recorded questions on my iPad here that people have sent me this week, and I'm going to do my best to try to get those all answered. We do have a lot to cover, so let's just kind of dive right into it. As you can probably tell, I'm in a hotel room outside of Houston, Texas, training all this week. Some quick disclaimers: laws and agency SOPs may be more restrictive. I'm just going to talk to you about general concepts. If I need to phone a friend, I got Michael Brave here, who is absolutely a liability expert, civil rights violations and so forth. If you have any doubts about the legality of your actions, push up the chain. And finally, this course is legal education, not legal advice. I'm just telling you what I think is some things important to consider. Duty to protect. I think that's something that cops are curious about. Like, what is your duty to protect? You might be kind of surprised at this, but generally speaking, there is no duty to protect people, right? You have no legal obligation to prevent harm to people, through your services. Now, you have a moral obligation, you have an ethical obligation, you have a code that you take in, right? You might have policy that requires you to be prompt in your responses to calls for service and so forth, right? So if you don't do your job, you may not be able to get sued for not helping somebody, right? Unless there's a special relationship, but you can certainly, and you should, get some criticism. Now, the seminal case is the Shaney versus Winnebago County, right? This is the case where the government arguably could have done more to save a kid to prevent the kid from getting permanent brain injury from his deadbeat father. The social services had evidence that the father was a deadbeat. He was a bad father, more than a deadbeat. He from what I remember, and Mike Brave can correct me if I'm wrong, but he basically pummeled his kid to become a vegetable. And very, very sad case. And the mom basically is like, hey, look, Winnebago County could have done more, right? They knew that my son was with a very bad person, and they didn't do enough to protect my son. And the Supreme Court, look, this ain't a Fourth Amendment issue. It's a due process issue, right? You deprived my son of due process, and the Supreme Court said, look, we're not trying to be cold here, but nothing in the language of the due process clause itself requires the state to protect the life, liberty, and property of its citizens against invasion, by private actors, right? So yes, it's a sad outcome, and we expect cops to act, but sometimes they can't act. Even if they could act, maybe it's not the right thing to do, right? Let's watch this video, give you an example. Generally speaking, look, you don't know the whole story. There's always more to these stories, but based on what you see, if the cops are watching this guy drown, do they have a legal obligation under the due process clause? Maybe even if you can think of any state law, do they have a legal obligation to jump in that water and save him? Yes or no? Right? What do you think the answer is? Do they have a legal obligation? Okay. And the answer is no. The answer is no. So now, and I got to tell you, based on what I saw there, I would have done the exact same thing, meaning I would not have gone in and saved that guy, because I'm sorry, I'm an okay swimmer, but I'm not trained to support two people swimming, right, guys? So it's likely that the person would drown, the cops would drown too. Now, obviously make sure, this is going to be high profile. So, say the right things, have some compassion, have some emphasis here, guys, swim to the shore, stuff like that. But no, I do not see any liability in that case at all. So here's another example. And we are going to talk about like Uvalde type situations, right? There maybe there's some liability there. We'll see. Look, I have compassion, right? I have compassion, but he would get a little farther if he actually blamed the politicians, right, and the actual criminals about who broke into his business. At the end of the day, at the end of the day, cops don't have a legal obligation to protect, right? Whether it's safe and so forth, you have a moral obligation to do what you can, right? But it's just the way it is. Now, somebody, did talk about, somebody said, what if, I think they said, like, what if the cop has, for the swimming case, right? What if the cop has training that's a rescue swimmer? Let's say he's a rescue swimmer training, right? We're in the same boat. You still have no special relationship. The exception here is when the government has a relationship with you, right? And they had some kind of affirmative act that put you into that danger, right? That would be when this rule is a little different, right? So let's talk about detained and arrested suspects. I think it just makes sense for everybody that, if you are detained, right, or you detain somebody, or you arrest somebody, you have, some legal obligations there, right? I mean, especially when they're arrested, they lose what's called self-help, right? Now they can no longer, protect themselves, right? It's the same thing with, people in prison. People in prison are limited in their self-help, and the corrections officer have some obligations of the due process clause to kind of provide some protection. Now, that doesn't mean that they're, have to put themselves in harm's way and, get hurt themselves. They can wait for backup and so forth, but that's a little different. So let's talk about Dahmer. Or Domer, right? What happened here is this guy got into a fight, okay? And he was assaulted, and he, told police he did not want to get medical attention. Maybe he doesn't want the medical bill or whatever. He just wants to sleep it off, right? And the officers helped him get back to the hotel, and he was found 2 days later with a brain bleed, and he suffered permanent brain damage. Now, like all good victims, he wants to blame who? He doesn't want to blame himself. He doesn't want to blame the person who punched him in the face. He wants to blame the police, right? And he wants money from the taxpayer. So, and so forth. Now, somebody says, what if somebody's in custody and they escape from a vehicle and they run into the water? Do we have an obligation to save them? No, because they're no longer arrested, right? They're an escaped prisoner. They're not a prisoner. So they have self-help. They could have chosen not to put themselves, in the water, right? And the government did not do something to put them into the water, right? Anyway, so you get my point. Okay, so Brian says, so here there's no liability with the guy that suffered brain damage. What about a school resource officer during an active shooter incident? Is that a special relationship that creates an affirmative obligation act? I got to tell you that from, this is not my specialty. I know that, what was the cop in Florida? I know that they did prosecute him under some state claims, right? But I do not think they were successful. And Mike Brave, you can correct me if I'm wrong. I do not think they were successful. In fact, I don't think they're successful at all. Quite frankly, at the end of the day, wasn't he exonerated or acquitted? But I don't think they did not go after him under any kind of due process issue. It was still going to be under some kind of state law claim. But going back to Uvalde, there is this argument, that I've seen out there where if the government, i.e., police officers, are prohibiting, check this out, think about this argument. If they are prohibiting, let's say, parents from going into that school to save their kid, and they're preventing them, okay? Listen to what I'm saying. And like, no, you can't go in there. Do you think that there's an argument that they now have an obligation to do something? Yes or no, right? If you're preventing another person from helping, haven't you absorbed that? Haven't you absorbed that responsibility, right? And that's the way I look at that. Okay. And so that's the way I look at it. So I think that if it's called self-help, right? Or, and so if you prevent a parent from helping themselves, helping their kid, you have obligation on your hands. And so I think it's one thing to just watch the looting, but it's another thing to prevent people that can have the ability to do something to not do something, right? Yeah. Okay, let's talk about Jeffrey Dahmer. Okay, this is really great pick, by the way. Man, it looks like Jeffrey Dahmer. So this is a situation where, Jeffrey Dahmer. So it's the bizarre case in the extreme. Okay, so before they knew it was Jeffrey Dahmer, okay, they had contact with Jeffrey Dahmer. And Milwaukee police, what happened here was they got a call for service that there was a naked man screaming and so forth in the streets. Okay, they arrive, and Jeffrey Dahmer, he arrived too, right? And he says, "Oh, we're just having some boyfriend trouble. Okay, we're just having a domestic, essentially." And look, they just the cops, pretty much blew it off, right? They're like, okay, here they returned this naked, screaming kid, and wait till you hear how old he is, back to Jeffrey Dahmer. Now, clearly, they did not know who Jeffrey Dahmer was. He became obviously a serial killer. They knew afterwards, but after they returned him to Jeffrey Dahmer killed this kid. Okay, and he was already going to die before he escaped. He actually was drugged, and he actually came out of the stupor that Jeffrey Dahmer put him in. The question for us is, did they do something affirmative here, right? Did they actually have a legal obligation to do more than what they did? And the answer is going to be yes, right? The court found that there was a special relationship between the parents and, the son, right? So the police had an obligation. They did such a crappy investigation, right? They did such a crappy investigation. I thought I had a video in here of this, but also detained and arrested suspects can sue, right? So now we have affirmative conduct that creates foreseeable harm. This is when you do something that can actually contribute to the liability, right? So usually you have to do something, plus it has to be foreseeable, right? Let me give you an example, right? If you let let's say you stop a drunk driver, right? And the driver goes to jail, and he has a friend, and his friend is also intoxicated. But you're on a city street, and the guy just wants to, go home, right? He just wants to walk home. I don't know. I mean, do you think that's necessarily he's going to get hurt, get killed, right? If he just walks home, that's right, Mark. The kid was like 14. I thought there was a video on this. I don't know what happened to it, but he's like 14 years old, right? So I don't know. Probably not, right? I mean, you allowed the guy to walk home, but is it really foreseeable? Change the facts. How about you let the passenger walk home on the side of a freeway, right? A limited access freeway, and he's super intoxicated, and you see him kind of like stumbling, and he stumbles into the oncoming traffic and gets killed. Is that affirmative action with foreseeable danger? The answer is probably yes, right? So that'd be a problem. So the husband and wife, they go to court, the wife gets a temporary protective order against the husband. Okay. He also has a warrant, but they choose not to arrest him on the warrant. They just choose to give him a verbal warning and say, "Hey, go take care of your failure to appear." So then he leaves. He goes to his car. He grabs a knife and he kills the pregnant wife on the door on the courthouse steps. And now the family of the wife, right? They want to sue the cop that did not arrest this guy, right? What do you guys think? Did they do something affirmative that created foreseeable harm? Yes or no? I think so. Casey says that what if somebody consumes narcotics and goes into like cardiac arrest, the cops just summon EMS, but don't do anything to save him, and he's under arrest, right? And the guy dies. Yet the cops have some CPR training. I think that's a problem. I think it's a problem. I think they have an obligation there. The guy's in custody, and it would be something to decide for courts whether or not what they did was reasonable under the circumstances, right? Okay, so the answer is no, right? There is no liability here because look, there wasn't nothing affirmative to create that this conduct was foreseeable, right? People get TPOs and temporary protective orders all the time. They don't necessarily kill people over it, right? People are told that they have a warrant and they're not arrested all the time, right? A lot of places just cannot arrest every single person with a warrant, so they have some kind of discretion. And the answer is no. It's a sad case, but there's no liability. What about this case? Police investigated domestic violence involving an off-duty officer. Allegedly, the officers told the suspect that the victim deserved the abuse. This is the allegations. I wasn't there. And refused to make an arrest despite the court finding that there was probable cause to arrest this off-duty officer. The abuse continued. Did these officers do something affirmative that caused foreseeable harm? Yes or no, right? And the answer, yes, is yes. The answer is yes. Okay. So this is a case that I cannot find the citation for, right? But I heard about this case. I read about this case many years ago. But what happened here is police ejected an unruly patron from a bar during the winter. He wanted to go in and get his jacket to walk home, but they refused. They were like this. Their attitude was like, "Hey, you've overstayed your welcome, and so forth." So they find him frozen to death in an alley 6 hours later. Is there liability? Yes or no? Taylor saying yes. Okay. Michael, Taylor, please change your chat settings to everybody. Okay. And the answer is yes, right? Maybe he would have frozen regardless, but they contributed to it. They did something affirmative that contributed to his harm, right? They should have known that the guy should be able to get his jacket. Scott Peterson, right? Didn't Scott Peterson get charged for failing to act in the Park school shooting case? Man, this is out of whack, right? So Peterson was charged with various state offenses, but not constitutional violations. That's what I was talking about. The school issue. So going back to Uvalde, Scott Peterson, I don't think prevented anyone necessarily from going into that school and taking out the shooter. In Uvalde, they did. Right? They did prevent parents from going in there. And to me, that is a different issue. Let's talk about the exclusionary rule, right? Since I just kind of threw in a mix of things here. The exclusionary rule is when there is a violation of the Fourth Amendment and the evidence will be excluded at trial, right? So why do we exclude evidence that's tainted? Why? Because we don't want to encourage bad conduct. We want our police officers to do everything on the up and up. If police officers had no consequence, with their violations, then they would just, presumably the argument is that they'll just violate people's rights in order to kind of get a conviction. Well, there's two things that happen to police officers when they violate people's rights. Number one is the evidence can be suppressed, but even if the evidence doesn't get suppressed necessarily, they can be sued, right? As Justice Cardozo said, the criminal is to go free because the constable blundered, right? So if you blunder, then the criminal gets to go free and be a free person. That's not good, right? That's not good. Maybe here's a good example of what the exclusionary rule is. What an absolute scumbag. It's all your body parts. Yeah, I'm just I'm just glad I'm on this side of the fence, about helping put these guys away for their body parts, not helping them get free. Now, one thing I want to bring up, right? Just like I like him. One thing I want to bring up is inevitable discovery. The reason I want to bring this up is because I got to tell you, it's one of the more misunderstood things that I've seen in law enforcement. Cops think that if the evidence could have been discovered by some other means, that it's going to come in, right? No. Inevitable discovery is based on the facts and circumstances. When you did whatever the court said was unlawful, right? You did a bad, you searched the car without probable cause, okay? Bad search. And then you're like, okay, well, inevitable discovery. And you're like, why inevitable discovery? And the cop will say, because I could have towed the car, right? The guy had no license. Therefore, I could have towed the car and found the same drugs under the seat through an inventory. That's not inevitable discovery. Inevitable discovery is, would you have? So the question for the cop is, okay, at the time of the bad search, at the time that you went to that car thinking you had PC, were you going to tow it? No, I wasn't there yet. I was going to search it first. Then that's not inevitable discovery. But the cop says, no, we were going to tow the car, right? Because we don't let these cars go with people with bad licenses. That is inevitable discovery. Does that make sense? Right? So it's not that you could have, it's that you would have. Okay, Eric Solis. So what happened here, Eric is involved in a shooting, and here's the crime scene real quick. Yeah, so look, I'm just going to give you some context here. This is the shooting scene. Not really a lot to talk about here, but I just found it on the 90. So what happened here is what happened here was, and I'll answer your question in a second, Brian, is that they found that he was Solis was staying at his woman's apartment. I think it was his sister's, but regardless, and that they. So the woman came out, and she said, they were going to keep everybody out of the house because they're looking for the murder weapon, right? And they get her and they go into the house to secure the house for a search warrant, but also because she has kids. So far, so good, right? They're trying to get the kids out of the apartment because they're young kids. But then they unzipped a bag and found the murder weapon like in plain view. Will inevitable discovery save what they did with that bag? Yes or no? Right? They went into the house. They were going to get a search warrant. They're pulling these kids out. They looked into the bag. Will inevitable discovery find the evidence? And actually, the answer is yes. Okay, it will. Did they do a bad search? Yes. That's why you need inevitable discovery. But would the evidence have been found with the search warrant? Yes. So at the time of the illegal activity, the unlawful searching of the bag, would they have found the gun? And the answer is yes, right? The answer is yes. Now, obviously, what I'm teaching you here is why we do this? I mean, the cop messed up. How can this all have been avoided by not searching the damn bag, right, my friends? That's why we're here. I don't want cops to search bags without horns. They need to do it the right way. Now, somebody said, what is the difference between inevitable discovery and independent source doctrine? They are siblings, but they are not the same thing. Inevitable discovery is, would you have found the evidence, right, based on what you knew at the time? Independent source doctrine is that at the time of the illegal search, was there something else going on independent of this investigation that would have also discovered the evidence? We don't want to penalize police or society by suppressing evidence that would have been found regardless. The most famous case in this, I think it's Williams versus Nix. And you tell me if I'm wrong. Who can tell? It's Williams versus Nix. It's the one where the police, got a legal confession from somebody who murdered a child, and the suspect told the police where the body was, but that was an illegal, unlawful, right? It's not Nix. Okay. So they told, I forget. They told the police went out there and found the body. However, kind of unbeknownst to the police officer at the time of the illegal confession and there was a search party, and the court found that the search party would have independently found the dead body, right? Something like that, right? Something like that. That I believe that's the right case, Manny. And they would have found the dead body regardless. That is independent source. You see the difference there? It's not quite, the cops didn't know they were going to find the body inevitably, but the court did, right? The court did. Okay. I hope you find this information useful. We got a lot to talk about. Civil rights liability, Section 1983. Let's just kind of talk about it. Very overview. I actually have a whole course on this. But generally speaking, a 1983 lawsuit is maybe the most common. It's certainly a most common in federal court, right? It's a very, very common lawsuit. My understanding, and Mike Brave is here, let me see if Mike's still here. My understanding is that about 40,000 of these are filed every year against the government, right? Not all police officers, but about 40,000 per year. Now, what it says essentially is it says every person who, under color of any statute, ordinance, regulation, custom, or usage, causes to be subjected any citizen of the United States to the jurisdiction there, or the person within a jurisdiction thereof, to the deprivation of any rights, privileges, or immunity secured by the Constitution and laws, shall be liable to the party injured in action at law, student equity, or other proper proceeding for redress. Thanks, Mike. So I'd like to understand essentially this 1983 action, and it's been around for many, many years. It really it got passed after the Civil War. I think it was really known as the Ku Klux Klan Act, right? 1871. It was really meant to go after government actors that were going also in cahoots with the private actors, the KKK, that were in concert violating people's rights, right? So you can go after private people too, but they got to be they have to be part of government action under color of law. So that's who we go after, right? We have to go after people who are acting under the color of law, right? So I used to be a cop, but I'm not a cop anymore. So I don't act under the color of law, right? I can't really violate people's Fourth Amendment rights or due process. That's just not my position. I'm a private actor. And if I did an illegal search, it is what it is. I can be arrested. I can be charged with burglary. I can be charged with whatever, theft, but I can't be charged I can't be sued under 1983 because I'm not a government actor. I didn't work for you, right? The next thing is, what can we sue about? Right now, there are tens and tens and tens of thousands of laws and regulations on the books, but only a handful of those are actually federal rights. And there's also state rights, but we don't talk about that here. A lot of states have their own analog to the Civil Rights Act, but for state constitutional deprivations. But what can we sue about? We can sue for federal rights. What is a federal right? How about the Voting Act, right? How about discriminating against somebody for their sex, gender, national origin, and so forth? How about the ADA? It was Nick's. Okay, good. How about here's all these, right? How about actually LEOSA has been found, which is the Law Enforcement Officer Safety Act, the law that allows you to carry concealed in all states. There was a court out there that said that is a right that can actually result in a 1983 civil suit. And what can we sue about? What can we get in return, right? If a plaintiff wins this lawsuit, they can get money from you, generally speaking. They also can get injunctions and so forth. But really, most of these lawsuits are about Jerry Maguire, show me the money. Now, why are these lawsuits in many ways, why are they so popular? Why are there 40,000 of them? You know why? Because you don't need to prove real damages. You can actually sue a police officer in federal court to make a point, right? To just show who's the boss, right? But here's the clincher. If the plaintiff wins, they get reasonable attorney's fees. They don't get anything they want, but they get reasonable attorney's fees. And that could be a lot of money. I knew a case in Nevada where the plaintiff got $14,000 in a settlement from the jury, in the jury. But then when it was all said and done, because the plaintiff won in their 1983 suit, the lawyer got over $350,000 in legal fees. And you're like, well, how the hell does that happen? Well, it just, fees add up quick, and the more you fight, the more, the bill is for the taxpayer if this case does not settle, right? Lawyers definitely make out, right? And yeah, Section 1988 is the attorney's award, right? And why do plaintiffs get attorney's fees? Normally, you don't get attorney's fees when you sue somebody, right? If I sue you because you chopped down my cherry tree, generally speaking, I do not get attorney's fees under just the general rules. But I do if the cop took my cherry tree, right? Illegally. They confiscated my cherry tree and they violated my Fourth Amendment rights. Why? Because quite frankly, who are mostly the plaintiffs in these cases? The poor, right? The disenfranchised, the people who don't have a lot of power in society, right? And the Congress thought that, look, if there was no incentive for lawyers to take these cases, meaning how are they going to get paid if we can prove that the government did an unlawful search or seizure, right? But if they don't get paid, if they have to depend on their client to pay them, well, a lot of these clients live in high crime areas and they drive Nissan Altimas. They just don't have a lot of money, and so they get the money through the taxpayer, right? They get the money through the taxpayer. Now, will it be a defense if the chair broke out? Will it be a defense if the officer sincerely believed, right, that he was engaged in lawful activity, but later is proved wrong, like good faith? Let me just give you an example, okay? There was a case where the cops did an unlawful knock and talk, okay? They basically pounded on this guy's door, okay, incessantly to come out to submit to a probable cause arrest. You guys with me on this? So they just come out, not the Altima. There's some truth to that. That in Pontiac Grand Prix. And I'll throw in, look, I'll be fair, Taylor. I'm going to be fair. Altimas, Grand Prix, and 300s. There's some truth to it. And so the thing is, the cops just pound on this guy's door incessantly and demand that he came out. But they didn't have exigency. They did not have a warrant, right? They just had PC. The court found that violated this guy's rights. But do you think the cops had bad faith? You think the cops, when they were pounding on that guy's door, thought they were violating this guy's constitutional rights to be free from reasonable search and seizure, right? No, they did not. So let me ask you, when they got sued in that issue, right, under 1983, did their good faith save them? Yes or no? Shame. Did their good faith save them from civil liability? Yes or no? Right? Okay. And the answer is no, right? As the court said, good faith is incompatible with objective reasonableness. Therefore, the focus is not on good faith, but on whether or not the law was clearly established at the time. I think that there's two things that are very misunderstood in law enforcement. Inevitable discovery, a lot of cops think that if it could have been discovered, it will be admitted. And the other one is good faith. Good faith is not what we're looking for in warrantless searches and seizures. Instead, we're looking for objective reasonableness, meaning, whether law is clearly established and so forth. It's not in other words, it's not what you feel. I think people misunderstand good faith. It's not what you feel. It's what you can articulate, right? It's what you can articulate. Let's look at this case from Bosch, the show on Amazon Prime. I'm sorry, a little foul mouth, but that was actually very funny. Okay, so, but I show that because, and look, Mike Brave is the expert here. But Mike, I think that generally speaking, the framework is correct. What they just did in that show was absolutely correct. There's even some of the way that the judge was, but that's correct. If the plaintiff wins, they get reasonable attorney's fees. Now we don't know how much it's going to be, $1 and so forth, but that's what it is, right? And so A suspect was stopped in Chicago unlawfully. The court says a bad stop, no reasonable suspicion, fine, and they arrest him because he has no license. And when they get right, reasonable fees would need in 1976. Today, it's not. Yeah, we see that, right? And he gets arrested. They pull him out. They for no license, and so forth. They also see a gun in the car. They arrest him for the gun, no license, whatever. He spent 65 days in jail. The state's attorney realizes that this is a bad case. It ain't going to go anywhere because it's a bad stop, and he sues. He wants $110,000 for lost income, right? And so, you know, but the problem is that there's this rule, right, in litigation, this 1930 litigation, that basically the civil rights violation stops or ceases once the cops actually have probable cause, right? So they didn't have, or reasonable suspicion, but they didn't have probable cause here in the beginning, but they had the probable cause at the time that he has no license. So the jury awarded him $1. But how much did his attorney make? I don't know. But it's going to be a lot more than 33 cents. I want to also talk about these 242 indictments. A 242 indictment is a criminal charge, right? So I like to say that, 1983 is civil. It's all about Jerry Maguire, show me the money. Section 242 is about sending cops to prison, right? And they are rare, but they can happen, right? So it basically says whoever under color of any law willfully subjects a person to the deprivation of any rights, privileges, immunities, secured or protected by the Constitution or laws of the United States. It's 18. My bad. Thank you, Mike. It's 18. 18 USC. I'll get that fixed. Shall be fined or imprisoned for up to 1 year. If bodily injury results, shall be fined or imprisoned not more than 10 years, or both. And if death results, shall be fined or imprisoned for any term or for life, or be sentenced to death. So what has to be proven here that does not have to be proven in a 1983 case? What is that? What has to be proven here, but not in a 1983 case? Right? What element has to be proven in a 242? Okay. It's that intent issue, right? It's that willful. Now, in reality, this is very hard to prove, right? 242 indictments are reserved for the most egregious violations because it's extremely difficult to prove the officer willfully violated a person's rights. In my experience, they don't really say, yeah, I knew I was giving the guy a little street justice. Yeah, you caught me red-handed. I guess I'll take my licks. They don't say things like that. In my experience, cops who messed up, okay, lost their cool, had a really bad day, and or maybe even they knew they were completely violating people's rights. Even when they get caught, I'm just saying this. The reality is, when they get caught, they're doing what every criminal does, and it's trying to save their own bacon. So they say things like, "I thought he was going for my gun. I thought he had a gun. I thought he was armed and dangerous," and all these things. That's why I did it. And so, it doesn't happen often, but let's be honest, that it has happened, right? So 242 in action, the most famous, infamous, right, case is Rodney King, just like Brian said. So look, if you know your history, you kind of know what happened here. The 4 LAPD officers got indicted. The trial was moved to Simi Valley, a pretty nice place, right? They got acquitted, but things are not done. We're not done here. We got the LA riots. It's a little deja vu from the Rodney King riots. We're not done here, because who now comes in and hits these guys with charges? It's the DOJ, right? And they're going to hit these guys with 242 indictments. So on August 4th, the grand jury returned indictments against the 3 officers for willfully and intentionally using unreasonable force, and against the sergeant for willfully and permitting and failing to stop the lawful action on King, right? So their trial ended with Officer Powell and the sergeant getting 30 months in prison. I don't know if you guys maybe know your the little history here, but what was one of the key pieces of evidence that helped prove? And maybe you don't know this, and maybe it's a trick question. Maybe I don't know about enough, but I just remember when I read about this case, one of the key pieces of evidence that proved that these officers, had the willfulness to violate this guy's rights was the MDT. So LAPD was one of the very few agencies, quite frankly, in the early 90s that had computers in the car. And not only did they have that, they had a text messaging service, which I think is fascinating, right? I mean, just way before cell phones were, text messaging, but they could text each other, and they were texting each other very raunchy stuff and racist stuff about this incident. And the feds used those messages to help prove that the cops had this at the time of the beating. What is, our generation's Rodney King incident? Of course, it is the George Floyd incident. So the feds also went after, all four officers at the George Floyd incident under 242. So they also got indicted. And we know it rarely happens, but the state and the feds went after all four cops. And what's the end result? I think Chauvin got 28 years in state prison. I'm kind of guessing here, 26 in the federal. Officer Tao got 5 or 7 years, I think, for his part of it. And the rookie officers got something like a handful of years, in their trial. So, all right, that's where we're going to stop right there. We're not going to do intervene just because we simply do not have any time. And hold on one second. While I'm just kind of adjusting things real quick, I want you to hold on. I want you guys to please click on those links that Teresa sent out. It really means a lot to us. And I just have to figure out one thing real quick. So, yeah, I hear you, Rick, but I don't have a choice. So, all right. And actually, unfortunately, unfortunately, I don't have any trivia. The trivia is all stuff. This webinar was actually a little too long. So all the stuff that actually is, it's all those questions are actually we didn't even cover these things. So my bad, and we'll just kind of go from there. Okay. Let me just get this PowerPoint back up. You're welcome, guys. And I'm actually just gonna start answering some questions. So let me share again real quick. All right. All right, so here's what we're gonna do. So I want to, first of all, for those people that are watching online, I really appreciate it, guys. Thank you so much.